Aloha, and thank you for tuning in to our next podcast episode. Want to make sure you never miss an episode, as well as get tips on how to hire an attorney and be eligible for monthly prizes? It's easy. Just join our free membership called the Agent of Change membership. Text your name and your email to area code 808-670-3400. Make sure you text back agree. And also to check out our past episodes, just log into www.legaladviceinparadisepodcast.com. Now enjoy the next episode. Aloha.
Welcome to the Legal Advice in Paradise podcast, brought to you by www.legaladviceinparadise.com. Even in one of the most beautiful places in the world, life can be litigious. On this podcast, the best and brightest legal minds gather to help you navigate your way through every legal question you may face. This program will help you know your rights, know what steps to take, and help you find the best legal representation, all in simple, easy to understand terms. And now, here's your host, Justine Gronwald.
The beauty of mediation is that you can propose it and you can engage in it without ever going to court. You don't even have to bring a case.
And that's why I wanted you on this show, because, anything to prevent going to court in my eyes anymore, just because I went through it, if I could have prevented it, I would.
Yeah, and it's possible, but the thing about mediation is you need two willing parties.
Okay, two willing.
You may want it, but if the other side doesn't want it, it's possible down the line that a court may compel the two sides to mediate. But most of the time, it takes two willing parties.
Okay.
Plaintiff and defendant.
Okay.
Sometimes there are more parties involved. Whoever agrees can mediate. And the reason is that mediation is completely voluntary.
I see.
You agree to what you will do or won't do. Sometimes the remedies that are agreed to are things you could never get in court. For instance, in the employment area, one of the things about a wrongful termination case is that under common law, and this is common law, that's court-made law, not a statute made by Congress or the legislature. A statute can give you remedies that a court cannot. A court will not make an employer keep an employee on its roles. If the employer has fired the employee and the employee says, I was wrongfully terminated, under court-made law, like the Parnar case, that employee is relegated to seeking damages. That's it. That employee cannot seek reinstatement, which is getting my job back.
Getting a job back, yeah.
That employee cannot say, I want that guy fired who did this to me. No court is going to do that under the common law.
Okay.
Under statutory law, like the anti-discrimination laws, there are remedies written into the law that Congress and the legislature, in their different statutory acts, have decreed. And what they do is they do allow an employee to seek reinstatement.
Wow. So that's the difference.
Yes.
Yeah.
And, some employees actually do want to get rehired by the same employer who treated them badly, but under better conditions, of course.
Right. And because it's stability. I mean, to go out there and look for another job today is very difficult. And when you're trying to provide for your family and pay the bills.
Right. And so under those statutes, they're called fee-shifting statutes.
Fee shifting.
And that is critical when you assess whether or not you want to proceed with litigation as opposed to resolution. Because an employee who wins can get attorney's fees and costs. In other words, the attorney, whatever time the attorney has spent on the case, for the most part,
Gets awarded that.
will get an award of attorney's fees and costs. That shifts the fees from the plaintiff, employee, to the defendant, who must pay. And so the defendant, the employer, always faces the prospect of a double whammy. Not only losing to the plaintiff, but having to pay the plaintiff's attorney's fees.
Now, is that 100% or 40% of the fees?
It's up to what the judge deems reasonable.
Okay.
The judge determines, he has to look at the fee petition of the plaintiff's attorney and see whether it's reasonable or not.
Yeah.
And usually the plaintiff may seek a given amount and does not get all.
And in my
plaintiff's
case,
fees.
if I were to lose, which I did, I would have had to pay 40% of, the person that I went to court with, of their fees. But mine turned out to be different. He just withheld my commissions in return. So it was just
you were going under a contract, and then you weren't really at will, okay? And sometimes for a breach of contract, we're not talking about anti-discrimination statute. We're talking about a contract where you have agreed with another person as to the terms and conditions of your employment.
Yeah, this was a commission.
And sometimes the attorney's fees for breach of a contract are payable by the loser in a breach of contract case.
Right.
So if you lose, yes, according to the contract provision, you may be liable to pay the other side's fees.
Right.
In terms of a common law case, like the wrongful termination case of Eugenie Parner, she did not have the right to have her attorney's fees awarded because under common law, you don't get a fee shifting of your attorney's fees if you win. So there are different ways to look at a case depending on what you're claiming and under what law. So what a mediator does is try to see what each side is claiming in the way of an allegation or a defense. Look at the evidence in one side's favor as opposed to the other, and see what each side is willing to surrender.
And of course, we have to stress that it has to be both sides are willing to do it.
Pretty much. I mean, you can't get an agreement, which is the purpose of a mediation, to get the parties to yes. You can't get a yes unless both parties agree at some point. And usually, to even begin, you need a yes from both sides. As I've said, there are occasions when a mediation is compelled by the court of law. I want the two of you to get a mediator, and I want you to try to settle this case.
Wow, that's the judge.
That's a judge. And it does occur in some instances, and it's under state and federal cases that they'll do that. So the thing about mediation, though, is you can force the parties to table, but you cannot force them to drink. If they don't agree, they don't agree. And what a mediator has to do is to seek that point on the table where the parties can agree. And sometimes it's only partial, and the case nevertheless moves on, but they are able to resolve at least part of their dispute.
Right.
But most of the time you seek a full resolution.
And there's no real set timeline. This can go on for however long, right?
It can be done before a case even begins. You have a dispute in the workplace. It can be done by a non-lawyer. A non-lawyer can mediate. They do it in schools. The DOE has a mediation program where students mediate disputes.
No kidding.
Oh, yes.
Wow.
Anybody can mediate who is able to facilitate communication between the two sides and who knows enough
Right, that's
about
the key,
the
though.
area
Right,
that
that's the
is in
key.
dispute to be able to have a meaningful discussion with both sides. So mediation is not necessarily confined to the legal arena, and it's not necessarily performed by lawyers. They do it
see.
in construction disputes where non-lawyers, former contractors,
Because they have the knowledge.
yes, they can mediate disputes. They arbitrate disputes in certain fields of discipline.
Wow. So when somebody goes into mediation, you don't know how long that's going to last. It's kind of like a court case. You don't know how long it's going to last. You just try to, or do people try to say, okay, let's give this an amount of time, like 60, 90 days. Do they put any kind of time on there?
A court can impose a time frame, but generally speaking, the parties set their time frame, and most mediations occur on a specific day
Okay.
and time where everybody gathers in one room, at least in the beginning. And the mediator convenes the discussion. And then after that plenary session, which can take a couple of minutes
Oh, a couple of
to a
minutes?
couple of hours.
Wow.
It depends
Right,
on the
right.
situation.
I see.
But it can be just an introductory meeting where both parties agree to do their best to try to reach a resolution. And they understand that whatever is communicated in the course of the mediation is confidential.
Oh, okay.
It cannot be used in the litigation for
I
the most part.
I was going to ask you now, can that information be taken to a deposition? But maybe the deposition's already done, but can it be brought into the court? If it ends up not
It
being
is not
able
supposed to be,
Oh, okay.
okay? But you can't unring a bell.
I like that saying, you can't unring a bell.
If you've heard a bell in the mediation,
Right.
you can't use it in the litigation against the other side. But you've heard it. That's why most of the time you communicate it only to the mediator.
I see.
And you give the mediator that information, and you tell the mediator that it's confidential or not confidential.
Okay.
Most of the time, the information that is conveyed in mediation is not confidential because the parties have already discussed it, or they're going to find out anyway in the course of what we call discovery,
Discovery.
right? So there are certain things, though, that will be conveyed only to the mediator in confidentiality, and it is obligatory on the mediator to hold that confidence and just use it as a means of trying to get the parties to yes.
I see. So there's a lot on your shoulders.
Well, not really, because it's really up to the parties. The mediator can assist them, can suggest things that maybe this party never considered.
And sometimes it's because they're so deep into this whole thing, they can't see other things outside of it.
Their wants are confined to, let's say, X. But if you give them a choice of maybe you can't get X, but you can get Y and Z. Have you thought about that?
Oh, so that's where the mediator comes in.
And then you go to the other side and you say, have you thought about X.
I see. So everybody's need can be met.
Yeah, and it's
As
usually
best as possible.
a question and answer session, and there are things that can be suggested, and sometimes the parties come up with them. The parties will say, well, I know that she doesn't really, I think what she would really like is she would like to have something else that she can't get in court. She wants to maybe help her son get a job somewhere, and because she doesn't really like living here, and if she could get some kind of living somewhere else, I can help her with that because I have friends there, and we'll give a little money to help her
that's
move.
definitely something you can't do in court.
You can't do that in court.
Yeah.
That's what I mean about being creative.
Okay. It sounds like it's like a together hooey type of thing.
Yes.
Okay, that's good.
So,
Yeah.
it's what the parties make of it or what they can agree to.
Yeah, okay. Now, let me ask you this. So both sides agree to it. So both sides will pay for the mediation outside of the attorney's fees.
Yes.
And how viable is that for an employee as far as, if they're, say they're not working anymore, they got fired, or they just don't have a job anymore. How viable is it for someone in that situation with no income coming in anymore?
Well, it depends on what the employee's agreement with the employee's attorney is.
I see. So it could be all rolled up in, say
It's
the
cost,
attorney.
It's a cost of litigation.
Okay, so maybe so in a case where attorney took maybe a retainer and the rest is on contingency, he's going to carry the cost for
It depends on what
that
that agreement
I
is.
see. Okay.
But costs under the Code of Ethics for attorneys, a cost of litigation is always borne by the client. Now, attorneys can forgive costs, but generally speaking, the client is on the hook for costs. But very few employees or ex-employees can afford to pay attorneys by the hour.
Right. So it's
Attorneys' fees have become astronomical.
Yeah.
I started out 37 years ago. I think my first billing rate as an associate in a downtown law firm was
I gotta hear this one.
$45 an hour.
Oh, that's so unheard of.
Yeah, well,
I just talked to I interviewed an attorney. He said, I think the minimum now is $250, which used to be considered high, but that's a pretty basic standard with the starting rate now.
Well, it really depends on what kind of practice you have, what kind of expertise you have, where you are in your experience. For a young attorney just starting out to charge $250 an hour is pretty steep.
Yeah, it's steep.
Very steep.
I'm thinking it's more like in the area of 100 or so.
Well, I can't speak to that. It really depends on where you are,
And
what you're doing,
what the expertise
what
is.
your experience is. But it's now gone, into the stratosphere. Hawaii attorneys actually bill less.
Wow, that's good to know.
No, you didn't let me finish.
Oh!
New York attorneys and San Francisco attorneys and LA
Are the highest.
Large metropolitan centers with large law firms have really high billing rates.
That's the stratosphere that you're talking about.
Yes, really high. And that's why mediation and arbitration have come into vogue. Who can afford to pay us?
Yeah. Right.
Abraham Lincoln represented his clients for, a chicken and maybe a few eggs, but I don't think that's the going rate these days. So when the cost of litigation becomes too much to bear, then you have to ask, all right, is justice being served? If justice is not being served this way, then what are the alternatives?
Right.
The alternatives right now are, go fish, forget it, mediation, arbitration, or let's you and I sit down and talk.
Like it would have probably done centuries ago.
Well, no, they had clubs then.
Oh.
Yes, but we want to avoid bloodshed, so we have courts.
Yes.
And now we want to avoid, court litigation and payment of extraordinary attorney's fees and costs. And we want to try to make parties live with what they can achieve. Not with what they can win, because winning is still extraordinarily hard to do. Parnar,
10 years.
it took 10 years. In those 10 years, she did not work.
Wow.
You have one life.
Right.
This is a story I tell to some employment plaintiffs. I had 2 cases where the plaintiffs were women. One was a tenured professor at the University of Hawaii.
Wow.
And the other was Eugenie Parnar. And it took both of them in separate cases 10 years.
That's a long time to
From
have that over your head.
termination to winning the judgment and getting the money.
Wow.
And in those 10 years, neither of them was able to work. They suffered reverses in their personal lives. I know that the tenured professor was adjudged totally disabled under law and was never able to work again. And when you consider that we don't go on forever, but there is an end to our existence, then you have to ask yourself,
Is it worth it?
Is it worth it? For the chance at achieving what you want?
Do you think these women, though, because of their cases, set the precedents and what what people can, attorneys can fall back on their cases?
Well, thank goodness for them, because
That's what I'm
they
saying.
paved roads
Right.
that other women and other men can follow.
Yeah, as far as the employees go.
But at what a cost?
Right. And typically that's always what happens. Somebody has to suffer a tragedy for others to benefit from later, right?
So whenever I had a client, and don't call me anymore. I don't take litigation cases anymore. I do alternative dispute resolution. But when I did have clients or potential clients come to see me and say, I want to have my day in court and I have a great case.
So you have to talk them off the ledge.
And I have to say, do you understand what you are asking
right.
for?
What it
You're
entails.
asking for damages. Do you know what damages are? They're to redress your injuries. Do you really want to be damaged?
That's
Do
a
you
good way to look at
understand
it.
what $1 million is? It's not pie in the sky. It's what a jury thinks you are entitled to because you're damaged in that amount. That's what it would take to address your injuries and repair you. Do you even want to get to that point?
That's a good way to see it.
And people just read the headlines and they don't necessarily understand that $1 million, it's not something that is on a grocery list. You don't go shopping for claims with $1 million price tag and say, well, that's what I want and I'll pay that. Claims they vary from person to person, from situation to situation.
It's true.
You may be very injured. Let's say you have an employment case, but you participated in that, and you're partly responsible. So you're going to have to mitigate your damages. Not only that, you're going to have to mitigate your damages by going out and trying to find another job.
Right.
And if you don't do that, you don't get damages.
Yeah.
Did you know that?
I didn't know.
You have to do
And
it.
when I went to court, I was trying to tell them that rather than getting another job, I started my own business and everything.
That's good.
And that didn't fly either.
Oh, but that's still mitigation.
Yeah.
Okay, under the law.
And the attorney for his side said, well, she didn't go out and try and get a job. Well, I tried many things. I'm an entrepreneur. I mean,
You have to
that's
keep
just-
track of it too,
Yeah.
because you're going to subject yourself
yeah.
to the will and the whim of a jury
Oh yeah.
of
Yeah.
strangers.
I didn't have that, but I already know what it's like to be in the court.
Strangers.
Yeah.
They have to be strangers to you.
Yeah, of course.
And you're going to be subjecting yourself
Mm-hmm.
to their decision making.
Mm-hmm. Mm-hmm.
If they don't like you, can they be objective enough
Mm-hmm.
to give you justice?
Right.
We're human beings, all of us.
Mm-hmm.
The judge is a human being. And, one thing about the OJ case is that brought it home to a lot
Yeah.
of people.
Yeah.
Juries will do whatever juries do.
Yeah.
They'll run away. Or they'll be great. I believe in the jury system. I think juries are wonderful. And I think they come to a certain common sense, a group, collective common sense that underlies our system of justice. And I really think it's wonderful. But I have to tell people who want to rely on that in their case, you have no idea what they're going to take into account.
Mm-hmm. Mm-hmm.
You have to dress a certain way, behave a certain way. You're going to be on stage throughout
Right.
the trial, and not only in court, but out of court, because this is
yeah.
a small town.
Oh yes, especially in Hawaii.
And, they need to understand that.
Well, I know you have to be somewhere in a little bit.
Oh my goodness,
I know,
do.
but you know what? You have been so helpful.
Oh, well,
I mean,
thank you for
it's
inviting
like
me.
a lot of people what they don't understand going into this type of thing. People are not educated for any of this. So I thank you so much, Susan.
Thank you, Justine.
And at the end of our interview, we usually just shaka out in the video portion.
Okay.
And then in the audio part, we say aloha and ahui ho.
Aloha, ahui ho.
Perfect. Thank you.
Thank you for listening to the Legal Advice in Paradise podcast. For more information, visit www.legaladviceinparadise.com.